agreement. She's well, Katie's supposed to be coming in with money, 35K.
Okay, Chuck, it's right at 10 o'clock. Are we ready to start?
Yep.
Okay, very good. So it looks like we have all of our parties here. First of all, my name is Russ Means, and I've been appointed to be the pre-hearing conference officer for this appeal of the decision by the Colorado Mine Subsidence Protection Program to deny damages claims and stuff for 72 Saddle Mountain Road and also 74 Saddle Mountain Road. Properties owned by Austin, was it Rivenberg? Is that how you said it? Okay,
Yes, Rivenberg, thank you.
And Kinney and Ardith Lindquist, is that correct?
Correct.
Okay, so first a couple of quick introductions and stuff. I'm going to read down through the list of participants and stuff that I thought would be here to make sure everybody's present. So I have myself, I have Mr. Rivenberg is here, Mr. Lindquist is here. We have Charles Koyman, Chuck. He is the AG counsel for the Mineland Reclamation Board. Jeff Fugate is the AG counsel for the Division of Reclamation, Mining, and Safety. I have Jeff Graves, who is the Inactive Mines Program Director. Erica Crosby, who is the Senior Environmental Protection Specialist for the Inactive Mines Program. And then I also have Rachel Nicholas, who is the Mine Subsidence Protection Plan Administrator. So is there anybody else and stuff that's here? I think that covers everybody. So, as noted, my name is Russ Means, and I'm the Minerals Program Director for the Active Mines program here in the Division of Reclamation, Mining, and Safety. To be clear and stuff and that to the participants and stuff here, I do not have any authority in the Inactive Mines program, nor do I have any association with the Mine Safety, Mine Subsidence Protection Plan. So I was selected because of my 23 years of regulatory experience and also my familiarity with the hearing processes. So due to the fact that there is no formal appeal process for the MSPP program, we're kind of adopting and modifying some of the process lined out in Rule 2 of the Hard Rock and Construction Materials rules. So the goal is to familiarize parties with the board process. What we want to try to do is list and narrow the issues to be heard before the Mineland Reclamation Board, and if possible, set timetables for submission of exhibits and witnesses, and to establish timeframes for presentations and testimony before the board at the May 15th or 16th hearing. That date was selected by the appellants in this matter through my reading. So this hearing and stuff is unlike those specifically outlined in Rule 2. So the participation here is voluntary. So if you elect not to participate, we'll conclude the meeting. And if the parties don't participate, then as the hearing officer, I will submit a memo to the board and that noting our contact and recommendations. Just so you know, the board may accept recommendations, modify them, or reject it. And when under consideration before the board, all parties will have an opportunity to object to any or all of the recommendations and stuff that are in my memo in my document. So with that said, Mr. Rivenberg, do you wish to proceed with the pre-hearing conference?
Oh, absolutely.
Okay, thank you. Mr. Lindquist, you as well?
Yes.
Okay, thank you very much. So based on the information supplied to me, this appeal is for the MSPP program decision to deny damage claims at both properties that I've mentioned. Is that a fair characterization of what the appeal is about?
Yes.
Okay, some of the issues and stuff that I have noted in my reading and stuff in that is under the discussion before the board, and the appeal is the process involved in the decision. questions regarding the geotech report used in that decision, and then the basis for the MSSPP decision to deny. Is that a fair characterization?
That covers most of the issues. I didn't send it until this morning, a PDF kind of as an initial draft. Have you had a chance to review that?
I just looked at it very briefly, sir. So in that, so are there any other issues then that you wish and stuff to have under consideration that we can discuss here?
Yes, in the initial reply email I sent, actually don't recall if it was the initial or the follow-up email. I didn't receive a reply to either of those to Mr. Fugate and everyone that he had on the distro for that email. One of the questions that we've asked repeatedly is, from doing the research on the origins of the program, the federal law that funded Colorado and 5 other states is pretty clear that it was to be an insurance program. All of the other states did create insurance programs. Colorado is the only one that's not. And I've asked for the legal justification and how it is that Colorado is the only state that did not follow the letter of the federal law that funded it initially.
Okay. All right.
Russ,
well,
I can address that if you want me to. Jeff Fugate.
Okay, go ahead, Jeff, and then I'll have a comment and stuff too, but go ahead.
Sure. Mr. Ravenberg, thanks for raising that. And yes, I haven't responded to one of the emails that we exchanged earlier this month. We have been doing some research into kind of the origins of the program from its inception. We are putting together an exhibit. It's going to have kind of an outline or summary of the inception of the program. It will reference the applicable laws, as well as some of the discussions that the board had as trustees or initial trustees back in the I guess the late 80s, in the establishment and creation of the program, how it was funded, and how it's been operated. So I don't have that exhibit and information kind of put together in a shareable form yet, but we will. Obviously, we'll have it by the date that we exchange documents. If we have it sooner than that, we'll share it with you. We're also open to having a follow-up call with you to further discuss if you think that might be helpful. I do know that you've raised it as one of your main issues. We're still undecided as to whether or not that's relevant to the appeal here, but it's certainly something that we want to be able to discuss with the board or answer any questions from the board if they have questions on the inception of the program.
Sure, and I appreciate the situation, because with the relatively late notice and some of the rules, actually I appreciate your initial intro, Mr. Means, regarding that there has not been an appeal for this before and there's not a process for the appeal, which kind of, when I got the letter, and Kenny and I both got the letter dated 28 March with some of the procedures in there, which was like first heard for us, despite the appeal being filed back in January, with a really accelerated timeline from what we were expecting. We're in the same boat as you, Mr. Fugate, where the letter says everything has to be ready right now, but that was kind of a late notice of the timeline. So it's good to know that the rules being cited in that letter aren't actually specific to the Mine Substance Protection Program appeal process, which really doesn't exist. So it's really nice to know that. And if I could ask to get the notice of pre-hearing conference letter dated 28 March updated to reflect what the actual situation governing the appeal process for this is, I'd appreciate that.
Okay, and at the end of this process and stuff, I will be developing what's a draft pre-hearing order, and some of the things and stuff that we'll agree to and stuff today are dates for submittal of exhibits and those other things. And I know that May 3rd, and that was part of that letter, and I believe in stuff in that notice, it also said that or as agreed upon. So that gave the parties and stuff wiggle room and stuff to have those discussions and stuff there. So we'll address that. So
yeah, great. That was definitely high on my list, because it's just like you said, there in some parts of that letter there is no wiggle room, and then in other parts there are wiggle room. And how this was really going to work, frankly, the letter confused me more than it clarified anything.
Okay, yeah, and sometimes the stuff, formal letters and stuff and that don't convey and stuff, and that the intent and stuff and that, but that's part of what we have to deal with. So duly noted. So I will I will include a discussion and stuff on the origin and setup of the program and stuff, but I need all the parties to be aware that that could be challenged for its relevance before the board. And that, so there'll be a discussion and stuff in that. So
Certainly.
and,
Well, if I could expand on that, I think that the mine substance protection program's ability to meet the legislative intent that was set at the beginning is really what we're in question here, because it, frankly, from our perspective, it looks like the people involved at the time, which I understand they've all retired, at this point from the Colorado government, right? Saw an opportunity to get $3 million from the federal government, stick it in a trust fund to support an office. And the not meeting the intent of the program as originally authorized is literally at the core of our appeal, is that the mine substance protection program is not meeting the original legislative intent, which is why we're having this problem now. So from our perspective, that's literally the root cause of the current problem.
Okay, very well. As I noticed, I'm not here to make any decisions and stuff there, but I will be sure and stuff in that to include that in the pre-hearing draft and stuff there. So I got this morning stuff. The one thing I did notice is stuff that there was a list of witnesses in that. So we have a professor and stuff in that from Colorado School of Mines, and then also a reporter and stuff that are witnesses and stuff. Are those the only witnesses you're planning on having attend this hearing?
My understanding is the witnesses are to be subject matter experts, and those are really the two subject matter experts that we've identified, in working through this process. But actually appreciate a broader discussion of witnesses. So like I have several engineering reports regarding this house and the stability of its foundation after the mitigation work was done in 1984. All I have at that point are documents for that. Is that something that I'm required to try to get the author of the document to testify, or does the document stand on its own?
That's a legal question, but I believe it's stuff the documents would just stand on their own as an exhibit and stuff in your submittals and stuff in that. Chuck, do you want to weigh in on that?
Yeah, I mean, because this is an administrative proceeding, we follow the rules of procedure, but it's in a relaxed context. And I think if there were questions about the authenticity of those documents, you could see an objection from, a challenge from the other party. I don't know that they would do that. I think I would kind of leave that to Jeff Fugate to kind of feel that one. But, typically it's a question of, the board's looking at what the board's view of how the rules of evidence apply in these proceedings is, like I said, relaxed and kind of, we usually interpret it to get the maximum amount of information that the board will need to make a decision and, become informed about that decision. And so it's less that we're going to be holding your feet to the fire in terms of you have to have the original author to come in and authenticate it, and more of, can you show that it is what it is, and that's probably good enough for this proceeding. Jeff, I don't know if you've got.
Yeah, I guess I'll just kind of lodge initial thoughts. I'm not going to object to them wanting to submit some of their engineering reports. And Mr. Reidenberg, I know in your appeal, which I've also just had a little bit of time to review, you mentioned some engineering reports from the 1990s and 2018. I guess I would just reserve the right to not object based on foundation or authenticity, but more on relevancy. Until I see those, it's hard to know if it's something that I would object to or not.
Yeah.
I guess that's it. Submit it, give us a chance to review it, and then we'll decide if that's something that we want to object to or not to be part of this hearing.
Okay. Yeah, the content, both of those are reports that were done in conjunction with the sale of this home and addressing specifically the concern about expansive soils, which are a known problem in the area after the construction was done. And both of them state that the mitigation done in 1984 was sufficient and that, you know, the house should be stable for the remainder of its existence, which is directly relevant and encounters what the mine substance program claimed. I actually would really appreciate some formatting guidance. And because some of the files I have are a little large, the email is the letter says everything is to be emailed. Is there any issue? Because I've literally been doing this for like the last 2 years. I've had any number of emails bounce because attachments are too large. So some formatting guidance on providing you the supporting documents, and specifically there's a line in the list must also specify where other parties may review and obtain a copy of each exhibit. So, like, for example, these engineering studies from previous purchases of this property, Kenny's had his property for much longer. This one has changed hands more times. How do I go about doing that?
So we will touch on that, and that Cami Mosier is the board's administrator, and that information and stuff will be submitted to her. I believe it's stuff when we have big files and stuff like this and stuff, we create a Google file and stuff and that where items can be submitted and stuff to that. And so part of my closing and stuff discussions and stuff here will be getting in contact with Cami and stuff and that on formatting and the best ways to do big files, because we recognize and stuff that sometimes the stuff files are big and they get bounced. So we want to make sure we get all of the information correctly.
Okay, fantastic. It would really, you know, some sort of a Dropbox where instead of sending an email and hoping that it's processed, where everybody can open up a file architecture and see every file that's hanging in there to make sure that it's actually been added would really, I know that's technologically feasible. It'd be really nice to do that rather than the email. Did the email go through, Chase?
And that's understood. And I think that stuff that the state IT has issues with Dropbox itself, but we have a way of working around that. So
sure. Yeah. There's tons of Dropbox equivalents. Same thing for the U.S. government, you know.
Yep.
But the term Dropbox is just kind of thrown around, just like Kleenex, even though it's tissue paper, right?
I understand. Yes. So, all right. So, like I said, I will include the origins and setup of the program and stuff there, and that may be an initial discussion and stuff with the board and stuff. So, what I'd like to do and stuff is discuss the submission of exhibits and witnesses, and then from there and stuff, we'll talk about the process and stuff of the hearing itself. So, per rule 2 and stuff in that, we discussed that and stuff. The exhibits and witnesses were supposed to be submitted by close of business today, and because we're playing loose and stuff with that rule and stuff, we've agreed and stuff that we have a list of witnesses and stuff here from you. I believe and stuff. Jeff Hugate and stuff will provide a list of witnesses and stuff, but it's primarily and stuff staff. And that Jeff, will you get a list and stuff for us, or do you have one?
I can have one. I was waiting to exchange that until we had a deadline. I can certainly exchange our witness list fairly easily.
Yeah.
It won't be a surprise list. It'll be the MSPP staff involved with this and the Tetra Tech team that worked on the investigations. So I can circulate that later this afternoon or whatever deadline you establish.
Yeah, if I could have that by close of business today and stuff and that, then that way all parties and stuff hit the same deadline there. And then and that so we've agreed and stuff in that, and you've confirmed and stuff that the appellants and stuff, your witness list are the 2 people and stuff noted there besides yourselves. So I've got that. Also in our discussions and stuff and that, reading through this and stuff, I think it's been agreed upon that the exhibits and stuff all have to be submitted by no later than May 3rd, and to the board administrator, and that's the date, just so the parties know it's that aren't a part of this normal process and stuff there. That's the date that everybody for any hearings and stuff for the before the May board hearing and stuff has to have stuff submitted, so that the board has ample time to receive it and review it prior to the hearing and stuff, so that they at least have a fundamental knowledge and stuff of what we're discussing and stuff that day. So the format and stuff in general is PDF formats. And like I said, stuff, Cami is available and stuff during regular business hours. Her phone number is, the direct line to stuff is 303-866-3567, and her extension is 8136. If you call that number and stuff and that, she will help you working on the size of your files, and also how we're going to get things set up and stuff for the submission of those exhibits by May 3rd. So
Would you repeat that number one more time just to make sure I got it right?
yes, sir. It's 303-866-3567, and her extension is 8136. And as I noted, regular business hours and stuff in that are greatly appreciated. So
And that's for you. You've been saying Cami. I assume that's Camille Mohar.
Yes, I'm sorry. Yeah, it's Cami, but Ms. Boyar and stuff in that is Camille. So and also I need a note for clarity and stuff. And that this makes the lawyers happy, is that in her position she is responsible for administrative duties to the board, and she cannot offer any advice or direction on other than the assistance on the submittals and stuff there. So, so now that we've agreed on that,
Actually, could I ask for a little expansion? So when you said format, you were just talking about file formats, PDFs.
yes,
But like for the document that I kind of put together just as a complete WAG on that I sent this morning, is that the kind of like structure within a document? And for the lists, providing description, the list, there's some information. Can you have like a format of what we're supposed to have this list look like? Because there's any number of different ways if I was making a guess, and I'd rather follow the format that you guys are used to looking at within a document.
usually it's stuff with the submittals and stuff and that we ask you to tab the different files and stuff, so that it's easy enough to pull up, and that's for the board and stuff to pull up and look at the separate sections and stuff that you have there. But that is a question of stuff that really would be best with to discuss the stuff with Ms. Mosier and that. But yeah, but we do in general and stuff, we ask and stuff that the things be tabbed and stuff in a PDF form. And that so that it's easy for us to send to the Mineland Reclamation Board individually, and that way it's easy for them to look at those and go to the different tabs and stuff for that to take a look at the subjects and stuff there.
Sure. Yeah, that's part of the reason I was asking, because I'm pretty accustomed to providing information to decision makers, and following a format makes it easier for them. And I just want to follow the format that they're used to, so that way this flows as easily as we can make it flow. But I'll follow up with Cami to get that kind of.
Yeah, you bet. She'll appreciate it, and so will the board and stuff. So a little bit of continuity and stuff is always helpful. So now that we've agreed on the that, let's talk about a little bit about our times and stuff in that for the actual hearing itself. The first question I have in that and you actually answer that in your submittal of stuff today, is that it looks like you guys you wish to have a single presentation for both of these. Is that correct?
Yeah, I mean, that's actually kind of consistent with the proposal that came from Mr. Fugate, because
Yep.
I mean, one of the core issues is that there was only one deep core hole for both properties. So from the beginning, the approach of the Mine Subsidence Protection Program was to merge these two. And that, I think, is definitely the most efficient way of approaching this. And, Kenny and I are in agreement. We've been working very closely with him, pulling some threads while I pull other threads. And I think it's in everybody's interest to keep it in as one proposal.
Great. My suggestion then is that the main presentation and stuff be singular and stuff and that, but would both parties like to have a brief opening statement and stuff in that as part of your presentation?
Of course.
So, Okay, all right, so with that in mind and stuff and that, then I have a proposal for the order of presentations, and then we'll talk a little bit about the time and stuff and that. So to be clear in that for everybody, you know, questions from the board during your presentations or at any time and stuff that doesn't count against anybody's allotted time. However, if you're doing cross-examination and stuff, that does count and stuff as part of your time and stuff. So, and so I have the following suggestions for discussion. We can modify them and then hopefully gain some agreement and stuff on that. So the order that I have in mind, based on past experiences, there'll be an introduction by DRMS, and that's just basically introducing the board to the matter at hand. And then as the appellants and stuff, you carry the burden and stuff in that for discussion. So you would present next to the board. Then there would be a presentation by DRMS. Then we would have rebuttals
Sorry to interrupt, but you had mentioned earlier time limits. As you hit each stage, can you tell us what the time limit is for each stage?
Yeah, I'm going to tell you the order, and then we will discuss the times and stuff for each one of those.
Okay.
Yeah. So, and then we'll do rebuttals by the appellant, rebuttals by DRMS, then closing by DRMS, and then the final closing is by the appellants. So as far as times go, I have a suggested time, and these are up for discussion and stuff. For the introduction by DRMS, I have 10 minutes. Is that acceptable?
Yes, that works.
Okay. For the presentation by the appellants, I have a breakdown of a 10-minute opening per appellant, and then 45 minutes for a joint presentation for a total of 65 minutes. Is that enough time?
Does that include any? I'm just trying to understand the process, how like expert witnesses work. Is that so? If that the 45 minutes would include any statements made by either Dr. Akunda or Ms. Shin, or should we just be presenting everything and they're there to answer questions from the board? How does that really work?
Chuck, if you want,
Yeah. It's up to you on how you want to structure your presentation. So, you know, if their testimony is how you want to present the information from the board, I would recommend that you budget that into the 45 minutes. But if you want to have them, you know, if you're going to do the bulk of the presentation and have them there to sort of be, you know, pinch hitters if there's a question from the board or something like that, that's entirely up to you. You know, you've seen it done a lot of different ways. It just sort of, it's kind of incumbent on you to take a look at, well, this is the points we want to make. This is how we want to make them. And if having one of your subject matter experts be the person who talks about that and does that part of the presentation, that's entirely your call. You know, there's always a bit of a, you know, the more times you're changing seats in terms of who's talking, that can, you know, kind of introduce delays. We're pretty relaxed in terms of, you know, I'm usually the one running the clock. I'll press pause if you've got to, you know, switch out somebody in the seat. It's not that big of a deal, but you know, we'll have everybody sworn in, and anybody who may testify will be sworn in at the beginning, and so up to you whether you actually call them or not.
Okay.
And in what.
So, so there's not a requirement that everyone who's a subject matter expert has to speak during that 45 minutes. There, you know, honestly, as I, you know, thinking through this, what I'd probably like to have is Dr. Kaunda present a portion of that 45 minutes, but Ms. Shin probably just be present to field questions if when her reporting and her you know, published reporting, if there's any questions regarding that, she can answer it, but not have her be part of. Would that be an okay structure to not have all of the subject matter experts actually participate in that 45-minute block?
Yeah, that's fine. Like I said, it's entirely up to the parties to decide how they want to structure their presentation. You know, there's years of past board meetings on the YouTube channel. And I don't know how far that rabbit hole you want to go, but you could take a look at some of the older, particularly permit applications that are contested and sort of see how they went. It might be educational, both in terms of what you want to do and what you don't want to do.
Yeah.
But
Actually, since this, my understanding is the first time this particular thing has ever been heard by the board, I would sincerely appreciate if one of the experts who have been on your side could make a recommendation of, this is an example from the YouTube historical channel of something that's probably the closest parallel of what we're going to do. Because if I was to go in and just start wading through, it could take me days and I still may not find something that's appropriate. Whereas you guys who've actually done this before may off the top of your head is like, oh yeah, this one 7 months ago is probably the closest fit. If you could point us towards that as an example, that would be hugely helpful.
yeah, I'm trying to think. Jeff, are there any, kind of contested permit applications that spring to mind where we had,
It's
some of
been,
them are long. It's been a while since we've had one.
I was gonna say, the formatting of this one is similar to a permit application with objecting parties. There are other appeals that the board hears, appeals of denials of permits or denials of other requests that are similar in kind of legal posture and burdens of proof. But I think for an example of how this hearing might look, and I don't have specifics of the last time the board had a contested permit hearing, but on the YouTube channel, you should be able to find some of those or look through some of, on the division's website, there are archived agendas. You can read the captions to those agendas to find permit hearings and then try to match those up to the YouTube channel hearings. But that gives you the format of staff presenting, calling experts, presenting rebuttal testimony, and other parties also then presenting direct testimony and calling their own experts, and how to kind of manage your hearing, what makes sense, what doesn't make sense. I don't have specifics off the top of my mind as to kind of what to search for initially, but those would be the closest to kind of format of what this hearing might look like.
I would think that, both sides would want to kind of have this is what we kind of expect it to go. And since you guys definitely have more expertise on finding this, is it too much to ask that Kenny I be provided with a link of, this is a hearing that is broadly similar to how we think this one will go? Or do we have to wade through this ourselves?
Jeff and Ed, I can take a look and maybe provide you with a couple of examples and stuff. So, and
That would be sincerely appreciated. Thank you.
It'll be nothing more than, like I said, the link and that and stuff and that. But I'll try to do the best I can and stuff there. So
Having had the experience of trying to find something that's a video link that's appropriate, because it's very hard to search videos if you don't, have some sort of background to it. That could be, for someone who's not familiar with the process and the keywords and really doesn't even have a starting point, the amount of time it would take Kenny and I to find something that, and then what we find might not be appropriate because we don't know what appropriate looks like, whereas the people sitting there have a better idea. So I really appreciate you doing that.
Okay, I'll try to get you a couple of links and stuff there, and that it may take me a day or two and stuff and that, but yeah.
If you can have it by the end of the month, that's fine.
All right, very good. So, and also I want to make it really clear and stuff that, if you're agreeing to 65 minutes and stuff for total time, if you only take 5 minutes and stuff for your initial introduction and stuff and that, you have the full 65 minutes and stuff. So you can adjust your opening comments and stuff and that to accommodate if you think you need a little bit more time than that, if that's agreeable. So
yeah, that'll be fine.
Okay. Presentation time for the division. I had a suggested time and stuff of 60 minutes. Is that enough time?
That'll work. I mean, I think we'll just kind of stay aligned with the other presentation. 65 minutes will cover enough of the topics between staff and experts.
Very good. All right. For rebuttal time for the appellants, I have a suggested time of 15 minutes. That's 15 minutes of stuff to, like I said, rebut any testimony and stuff and, do any cross-examination if you feel it's necessary.
I think that would probably be sufficient, but how long of a break between each one of these sessions will there be? Is it like, the 60 minutes over and it rolls immediately into the 15 minutes, or would there be 5-10 minutes to kind of structure what we want to do in the rebuttal?
Typically, that's up to the board chair and sometimes the stuff we take a break and stuff between, we get to a point and stuff where everybody does presentations and then we take a quick, coffee break or whatever, potty break and stuff and that, and then, go from there. So, it's more like, but I can't guarantee that and that. So, but there usually are breaks and stuff in these long hearings and stuff and that for a variety of reasons. So.
Yeah, the 2 straight hours. I think everybody's going to need a comfort break after the first couple presentations.
I agree. So, and that, so if 15 minutes works and that's fine. And, as noted in that, if after, considering it and stuff and that you want a little additional time and stuff, you can ask the board and stuff at the beginning of the hearing and that, but that'll be up to you to decide there. So DRMS, is 15 minutes worth of rebuttal time and stuff sufficient?
I mean, I guess I would ask, I'm not sure what you're gonna do with closing, but if we're doing kind of a joint rebuttal closing, if we could get 30 minutes for both.
Yeah.
That would be my request.
Yeah, I had 15 minutes of stuff for rebuttal and then moving to right into closing and stuff. I had DRMS for a suggested time of 15 minutes. So that would give you your 30 minutes.
Yep.
Okay. And then in final closing for the appellants and stuff, I had 15 minutes for closing. So that gives you that 30 minutes as well, if you will, and stuff. It's just that it's broken up and stuff so that you have the last opportunity and stuff to address the board before they close testimony. Is that good?
Yeah, that should be fine.
Okay.
Sorry to interrupt, Mr. Ravenberg, I wanted to kind of bring back one of the comments that Russ made at the beginning that maybe didn't make sense then, but might make sense now. The board is likely to ask questions of you, of your experts. They'll ask questions of staff and our experts. That time doesn't count against these allocations.
Yes.
Chuck kind of stops the clock to field those questions. That way you don't lose all of your time to fielding questions and lose presentation time.
Yep. No, I had the pleasure of testifying to Congress once earlier in my career. So when he had made that comment, it's not something that was completely unfamiliar for me. So I was assuming that it was going to be that the questions would not eat into our time.
Right.
Is there any limit on the board's time for questions, just out of curiosity? Because sometimes that's an issue.
Yeah. No. Yeah. Chuck, go ahead.
Yeah, we've never, since the board runs their own show, they'll take as much time as they like. Sometimes the chair may try to channel a discussion to move things along, but yeah, I'm not running a clock on their questions.
Okay.
Okay. With everybody accepting my suggested times, that's about 195 minutes or 3¼ hours. So it'll probably be 3 to 3½ hours and stuff for this hearing. So and that. So to recap and stuff, I have your contact information. My apologies to Kenny and stuff. I added a D in the original email that I had and stuff for Cruise and Creations instead of and that, but I got that corrected. And that, so I've got your contact information and who attended today. I will be working on sending out all parties a copy of the proposed hearing, which outlines everything that we've agreed to here and stuff on that. My goal and stuff is to have this to you by April 19th, which is next Friday. In that, so we've agreed that all submissions of exhibits and stuff must be received by 5 p.m. on May 3rd at the latest. If they're in earlier and stuff, the board administrator appreciates that. And then we've agreed on stuff on the order and the times and stuff and that for the hearing. So with that, the hearing is in, go ahead.
I did have one question on the exhibits that I didn't get to earlier. So with the the comprehensive report that Dr. Konda is doing for us, it's going to be citing other published research. So in the documents provided, do I just provide the report that Kenny and I have commissioned him to provide, or do we also have to provide copies of his cited research that supports his report?
I would, from past experience and stuff, I think just a citation and stuff, not the actual report and stuff is good enough.
Okay, great. That'll make things much simpler.
Yeah, and also, you know, a board packet with 20,000 pages and stuff is not looked upon kindly and stuff by the board. I'll be honest, and stuff with you there. So
I'm familiar with that dynamic.
Yeah,
Yes.
yeah. Okay, you bet. So, okay, so in closing the stuff, the hearing is in person at 1313 Sherman in room 318 on May 15th and 16th. Ms. Major will email you after the agenda is set or by May 10th to give all parties an idea of the date of the hearing. We highly recommend that you be here promptly at 9 a.m. as we can't guarantee the time. The board can adjust the agenda and stuff as it sees fit. So this item could move up or down in the agenda. But I will tell you, I will hazard a safe guess that this is going to be heard on the 15th, which is Wednesday the 15th. But as far as the time and stuff and that, I can't give you any kind of a guess on that, although it may probably be the first item on the agenda and stuff and that unless things are moved around. So are there any other further questions of you, Mr. Rivenberg, or Mr. Lindquist?
No, I for myself, I'll follow up with Cami on, you know, multiple levels of formatting questions to make sure everything's as easily understood and flows as easily as possible for the board. That's certainly important, I think, to everybody.
Okay.
And you know, now that we've got good comms, and will anything supporting from the mine substance protection program, when their stuff is uploaded for their side of the case, what is the mechanism for us getting copies of that? So we can
usually it's all like put into a Google folder, and then a link is sent directly to you guys so that everybody's stuff will be in that central folder and stuff there, so that all parties have the same link to the same issue. So
okay, great. So that's a Cami, work through Cami to get that.
Yeah, and just so you know and stuff like that, she's actually the administrator for our Zoom meeting, so she's probably listening in anyway.
Excellent. That makes things easier.
Yeah. So she will.
I am.
There you go. The voice from beyond. So
Yes,
in that, so
the wizard behind the curtain.
you got it. So all right, with that, I want to thank you guys for your time and your participation. Like I said, I'll get that board pre-order draft and stuff and that sent out to everybody. And then if there's any questions on that and stuff, I'll be sending it via email so you can respond back to me then. So, all right. With that, I will conclude the hearing, pre-hearing conference and stuff, and we will go from there. Thank you.
Thank you.
Thanks all.
Everyone.